How can the Labor Commissioner's Office help you recover your unpaid wages?
I usually work 10 to 12 hours a day, 6 days a week, sometimes 7. My employer did not pay me minimum wage or overtime or give me lunch breaks.
An employee or former employee may file an individual wage claim with the California Labor Commissioner's Office to recover unpaid wages. You don't need a lawyer to file a claim.
I heard from a family member that there's a claims process with the Labor Commissioner's Office for the money an employer owes you, and that you don't need to be a U.S. citizen or have legal immigration papers to file a claim.
Workers can file a wage claim with the Labor Commissioner regardless of immigration status. Filling out the claim form.
I was working as a janitor and usually worked 6 days a week, 9 to 12 hours a day. I was only paid $200 per week and didn't get paid minimum wage and overtime. My friend told me I should fill out a claim form that's available in multiple languages on the Labor Commissioner's website or at the local office of the Labor Commissioner. I got the claim form and filled it out. There's a question on the claim form where I could state if I needed an interpreter and in what language.
If you do not speak English and need an interpreter, be sure to let the Labor Commissioner know by indicating this on the claim form.
I asked the Labor Commissioner's Office when I had questions about filling out the claim form. The Labor Commissioner's Office also gave me a guide that went over each question of the claim form and a sheet of instructions on how to file my claim. To fill out the claim form, I answered questions such as my name and address, the name and address of my employer, the dates I worked, the hours that I worked, how much I was paid, and how much my employer owed me.
When filing a wage claim, you will need to provide information about the days and hours you worked for your employer. This information may be based on your own records if you kept a record of hours worked. Or, if you did not keep any time records, you can give your best estimate of the days and hours you worked, to the best of your recollection. Be as specific as possible. Notice of the settlement conference.
I worked more than 8 hours a day, 6 days a week as a day laborer, doing different jobs for my employer. I wasn't paid for all the hours that I worked, so I filed a wage claim with the Labor Commissioner's Office and went through the claims process. After I filed my claim, I got a notice in the mail saying that I needed to go to the Labor Commissioner's Office for something called a conference.
Both the employer and the worker will receive a notice from the Labor Commissioner after the claim is filed. In most cases, you will receive a notice to go to a settlement conference at the Labor Commissioner's Office. Make sure you attend any conference set by the Labor Commissioner at the date and time on the notice. If you are a worker, failure to attend a conference will usually result in your case being closed. If you're an employer who fails to attend the conference, in most cases, a hearing on the claim will be set for no later than 30 days from the conference. Preparing for the settlement conference.
To prepare for the conference, I've reviewed the facts of my claim, including the hours and days that I worked for my employer. I looked at my pay stubs to go over how much I was paid. I was also prepared to talk with the Labor Commissioner's Office about whether I had any witnesses who could support my claim.
Witnesses for either the worker or the employer should not be brought to the conference, but the parties should be ready to discuss with the Labor Commissioner's Office whether they have any supporting witnesses. The settlement conference.
When I went to the conference at the Labor Commissioner's Office, a person called a deputy was there from the Labor Commissioner's Office. My employer also came to the conference with his attorney.
Both the worker and the employer may bring a representative to the conference. The representative does not need to be an attorney. In addition, parties who do not speak English may request that the Labor Commissioner provide an interpreter in their language.
First, we all met together in one room.
Good morning. My name is Deputy Labor Commissioner Violeta Duron, and I will be conducting the conference today. Let me explain my role and the purpose of our session. The Labor Commissioner's job is to enforce the law. I am not representing either party. My job is to uphold California wage and hour laws and to make sure that you understand your rights and obligations under California law. If the law has been broken, this is your chance to remedy that without having to go to a hearing and without having to drag out your dispute. No one has to prove your case today. This is not a hearing.
At the conference, the deputy will discuss what is being claimed by the worker and the deputy's calculation of any wages, damages, and penalties owed by the employer if a violation of the law is found. The deputy will assist the parties by exploring whether they are interested in resolving the claim instead of going to a hearing.
During the conference, the deputy explained that we were at the conference to explore settlement and that the deputy would not allow evidence to be examined and debated. This really helped everyone focus on whether we could settle the claim and meant that conference time was used efficiently.
I'm going to separate the parties to see if I can help you resolve your differences, assess your risks, and get to a settlement.
In order to see if we could settle, the deputy talked with me in one room and with my employer in another room. The deputy talked to me about my claim amount.
So you've alleged that you typically work 10 hours a day, 6 days a week, for a period of 10 weeks.
Yes.
Okay. Based on what you've said happened, you would be entitled to approximately $2,400 in wages, $1,600 in liquidated damages.
The deputy also talked with me about the pros and cons of settling my claim and what amount I would be willing to accept to settle my claim. I could talk with the deputy about these issues without my employer present. The employer got the same opportunity to speak with the deputy too.
During the conference, it was very helpful to talk with the deputy one-on-one, separate from my employee. I could have a completely honest discussion with the deputy about the claim that was filed, whether I wanted to settle the claim, and what I thought was a fair settlement amount. I was able to consider any risks if I did not settle and went to a hearing, as well as whether my defense was strong, and if I would prefer to take my chances at a hearing. The deputy was compassionate and understanding, and spent time explaining the law and what I could expect next.
My employer and I were able to reach a settlement at the conference.
Settling the claims at the conference can be a positive way for both the worker and the employer to leave the dispute behind them, without the need to go to a hearing. The conference is a chance for both sides to see whether settlement is possible. At the same time, an employer is not required to make a settlement offer, and a worker is not obligated to accept one. The complaint.
I regularly worked 11 hours a day, 6 days a week picking crops, and I was not paid minimum wage or overtime, or allowed to stop working to eat a meal or to take a rest break. I filed a wage claim with the Labor Commissioner's office and went to the conference that was scheduled in my case. At the conference, the deputy asked if we could come to an agreement instead of going to a hearing. The employer offered an amount, but in my case, I didn't think it was a fair offer compared to the amount that I was claiming, so I didn't end up settling my claim at the conference.
Since you didn't reach a settlement today at the conference, your case will be set for a hearing. Your claim will be heard by a hearing officer who will issue a decision on your case. First, you will need to sign a complaint form so your claim can proceed to a hearing.
Because my claim didn't settle at the conference, the deputy prepared and reviewed a form with me called the complaint and asked me to sign it. This is the document that tells the employer what I am claiming for the hearing and how much I am claiming. The Labor Commissioner sends the complaint to the employer. I made sure I understood and agreed with the information on the complaint before I signed it. The deputy told us we would get another notice in the mail when a hearing is scheduled for my case.
All parties should promptly inform the Labor Commissioner's office in writing of any changes in address. Important information about the claim can only be provided to you if the Labor Commissioner has your current address. Notice of the hearing.
After I submitted my complaint, I received a notice in the mail from the Labor Commissioner's office about the date and time for the hearing on my claim.
Both the employer and the worker will receive notice of the hearing date and time from the Labor Commissioner's office. Make sure you attend any hearing scheduled. If you are a worker who fails to attend a hearing on your claim, in most cases your claim will be dismissed. Employers who fail to attend a hearing lose the opportunity to defend against the claim at the hearing. When an employer does not appear, the hearing will still be held if the worker comes to the hearing, and the hearing officer will decide the case based on the evidence and credible testimony provided by the worker. Preparing for the hearing.
I prepared for my hearing by looking over the information I submitted to the Labor Commissioner. I gathered and reviewed all of the proof I had, my pay stubs showing how much I was actually paid, and my calendar that I kept of the hours and dates that I worked. I made 2 sets of copies of my pay stubs and calendar to bring with me to the hearing, along with the original calendar and pay stubs. As I reviewed the facts of my claim, I also thought about the points my employer would try to make against my case and who he might bring as a witness. I wrote down a list of questions to ask my employer at the hearing that would help show I worked the hours that I did.
The hearing.
My hearing took place in a hearing room at the Labor Commissioner's office. Someone called the hearing officer from the Labor Commissioner's office sat at the front of the room. The hearing officer was like a judge. I sat down at one table facing the hearing officer. I brought someone from a community organization to help represent me. My employer, who came with an attorney, sat at another table.
Both the worker and the employer can bring a representative to the hearing. The representative does not need to be an attorney. In addition, parties who do not speak English may request the Labor Commissioner provide an interpreter for the hearing.
The hearing officer asks us all to raise our right hand and swear to tell the truth.
At the hearing, the parties and any witnesses testify under oath, and all testimony is recorded.
I picked lettuce usually from 6 a.m. to 5 p.m., Monday through Saturday, and I was told that if I took a break to rest or eat, someone else could come and take my place and I would lose my job. I only missed work for 2 days when I was sick. I was paid by the piece and was usually paid less than $300 per week.
During the hearing, workers should be prepared to talk about the basic facts of their claim, such as their dates of employment, job duties, hours, and days per week that they worked for the employer, and how much they were paid.
I brought the calendar I kept of the hours that I worked each day, which also show the days of work that I missed because I was sick. I also have some of my pay stubs with me, which helps show that I wasn't paid what I was owed.
Any party who would like to show documents to support their case at the hearing must bring the document to the hearing. Even if you have previously submitted a copy of the document to the Labor Commissioner, you should bring the original document, if you have it, plus 2 sets of copies to the hearing.
During the hearing, the employer's attorney had a chance to ask me questions about my testimony, including the hours that I worked and the personal calendar I kept.
It is the employer's legal obligation to keep an accurate record of hours and days worked by employees. If you are a worker who did not keep your own record of the hours that you worked, you can still testify about your work hours to the best of your recollection.
One of my coworkers came as my witness and testified about how many hours a day he typically saw me working.
I work next to him in the fields. On a typical day when I started working in the morning at 6 a.m., he was also there working. And at the end of the day, at about 5 p.m., we usually stop working for the day, but sometimes we work longer than 5 p.m.
The employer's attorney asked my coworker witness some questions. Then the employer gave his side.
I have a large workforce and more than enough workers in the fields to get the job done in 8 hours a day. My workers only work from 7:30 a.m. to 3:30 p.m., 5 days a week.
The employer also brought one witness who testified. The hearing officer gave me a chance to ask the employer and his witness some questions. Throughout the hearing officer also asked questions of both sides.
During the hearing, both sides had the chance to tell the hearing officer what happened and to ask questions of the other side. Everyone was treated with courtesy and respect throughout the process.
Both the worker and the employer have the opportunity at the hearing to present relevant evidence, including supporting documents and witnesses.
After the hearing was over, the hearing officer said that he would review the evidence and send us his written decision.
The hearing decision. Both the employer and the worker will be mailed the hearing officer's written hearing decision. Any party that does not agree with the hearing decision has 10 days to appeal the decision in court and must provide the Labor Commissioner with a copy of the appeal. If the employer does not appeal a Labor Commissioner hearing decision in the worker's favor, the decision becomes a final judgment that is entered in court. The worker can take action to enforce it and collect the money he or she is owed. The California Labor Commissioner's Office helps workers who have not been paid their lawful wages and educates employers and workers about California's labor laws.